Mr. Harty, welcome to another edition of the program Familiarize with the Law, coming to you from Star Television, Channel 21, where we broadcast live from our Media One Center, 3 Norma Streets, Book Frames in Freetown. We are live on Facebook and YouTube. With me in the studio, I have the Head of Operations, Financial Intelligence Unit, Lawyer Franklin Campbell. Campbell, good to have you in the studios.
Thank you for having me.
We pretty much understand that Sierra Leone is currently undergoing a mutual evaluation exercise. For the benefit of our insights, you may want to take us through the journey so that people may understand how did we come to that point for us to be assessed. What principally are we going to be assessed upon?
Thank you very much. Now, the issue of the mutual evaluation is a country process. It's a country process. Now, the regional FSRB, that is the Intergovernmental Action Group Against Money Laundering and Terrorism Financing, has been looking at how Sierra Leone's regime has been doing in terms of its robustness, in terms of its compliance with the relevant laws which are applicable, and also in terms of the effectiveness as to how these laws, are implemented or enforced. So therefore, it is not uncommon for countries who are members of the regional FATF-style regional body, that is GIABA, to come and look at what our systems are doing, how is the outlook of our anti-money laundering and terrorism financing regime in the country as a whole. Even though the Financial Intelligence Unit, is center stage of the process, but yet it is for the entire country. It's not the FIU's business alone. It's entirely for the country. Now, what GIABA will do, or what it has done already, because we are already in the process of the mutual evaluation, save that the on-site visit by the assessors themselves is yet to happen, and which is slated for next month. Now, they will come around and send questionnaires, so that asking questions about our laws. There are two aspects. The first one is the technical compliance. With technical compliance, what they are wanting to know is to see whether the laws are available. That is, whether we have criminalized money laundering, to what extent we have criminalized terrorism financing, to what extent we are dealing with record keeping, to what extent we are looking at how the reporting entities which we do that. What laws have been passed? If we say predicate offenses, the 21 predicate offenses noted by FATF, which countries should criminalize, okay, how do we as a country, what have we done to make those laws passed? Are they available? Have we passed the 21 predicate offenses? Have we criminalized laundering? Have we criminalized terrorism financing? To what extent have we dealt or localized the United Nations Security Council resolutions? We have the Security Council resolution 1263 and the 1730 to make it more difficult for terrorists to be able to move funds. Whether those laws have been passed, that is what one aspect we look at, the technical compliance. On the other hand, the effectiveness assessment, we look at to what extent are these laws being enforced. What is the extent of your enforcement? We as a country, not only Sierra Leone. Now, remember, in the regime as a whole, the FIU is one player. They have the judicial aspect of things. The judiciary, you have reporting entities, you have supervisory bodies, okay, you have law enforcement agencies like the police. Now, each of these segments have to play their own part in enforcing the law. And
I'm pretty much keen to know whether officials of the financial intelligence units could constitute part of the assessor board, the in-country officials.
no, well, we are the in country. Well, we won't be an accessory board. We won't be part of an accessory board, whether internal or external, because we as a country are being assessed, and Nemo Judex in causa sua applies. We cannot be a judge in our own cause. However, we have been working, with other players from the law enforcement, from supervisory bodies, from judicial authorities. We have all sat down around the table to look at these questionnaires. The questionnaires that have been sent to us asking questions about what I've just explained, the two ambits, the effectiveness questionnaire, and there is the technical compliance questionnaire. It will ask you about the laws, the issues of beneficial ownership, the issues of company registration, trust and company service providers, all of those things.
So as a country, are we nearing to having a very good score sheet at the end of the entire process?
I will say we are near to having a very fair score sheet. That is what I will say. Because from the indications we've been getting, we have been doing very well in some areas, and we have not been doing so very well in some other areas where there will be naturally room for improvement. For example, Sierra Leone is yet to pass the terrorism legislation, the terrorism law. There is no substantive law on terrorism as a country. Now that will mark us straight down. Well, that is not of the institutional players making. That is a matter for the highest authorities in the land to pass laws. So in those areas.
In most cases, you do recommend.
Yes, sure. Recommendations have been made, to the appropriate authorities. But these things are institutional and they take time. There are institutional rigors you have to have passed,
I was looking at a point where perhaps the biggest risk in all of those things you've highlighted may precipitate a kind of international isolation if we don't meet all of these set standards in all of these. Could that be the case?
Well, yes, because you will face the pressure of your peers. Everybody's like they say, Alma Mot go dey rub by you. What it will highlight good areas. Now let me take you through a presentation I did. It will highlight the good areas we have done, the areas we've done well. It would highlight, areas where we need improvement. But countries, I don't think we will reach the level where we would be deemed non-compliant to the extent of being isolated. Because there's a lot of work, even though there still needs to be some improvements. But there has been a lot of work which has been done in the area of ML and TF. Okay? Perhaps the marketing of what has been done has not been excessively robust. But I can vouch that a lot of work had been done. Even this afternoon, an amendment to the legislation, the anti-money laundering legislation, is being debated in Parliament because the director, the new leadership of the institution, wants a robust enforcement, of the provisions of the Act. So they've driven through Parliament, a set of amendments which will cure certain mistakes or certain defects in the effectiveness of our laws. So that itself, when passed, will be very great for our country.
I'm seeing you're having assessing technical compliance where perhaps you may just want to explain some of these slides.
Yes. Like I said in my opening statement, there are two ambits of the assessment. Two ambits. The first one being technical compliance, where I said They will be looking at the availability of the laws, whether the laws have been passed. And then the next one will be the effectiveness assessment. Now let's look clearly at what, in detail, what technical compliance comprises of. Okay, of course we've spoken about the laws, the regulations, means of enforcement, okay, whether these are available. We spoke about the 21 predicate offenses. How far has Sierra Leone gone to criminalize all of them? Do we have laws in place? If you say you have the laws, where are they? That is what technical compliance would look at. It will look at the powers of institutions in these laws. For example, the effectiveness of the functions of the FIU, for example. So apart from the powers and procedures of institutions, it will ensure that all elements of a particular recommendation, because the totality of the mutual evaluation is about compliance with the 40 recommendations of the Financial Action Task Force. That is the global standard setter. So the regional FATF-style regional body is going to come to Sierra Leone and look at how we have been complying with these 40 recommendations. Firstly, have we domesticated them in our laws? Yes, we have. I mean, those form the crux of the Anti-Money Laundering Act. All of it, emanates from the 40 recommendations of the Financial Action Task Force. They will be looking at to assess also the impact of data protection measures as well. If they appear to be effective, in the implementation of a robust anti-money laundering regime.
You also spoke of record keeping.
Yes, that will be part.
A very big challenge for
absolutely, that will be part of the technical compliance, whether the laws are available. For example, in Sierra Leone, the Anti-Money Laundering Act postulates that records, financial records, have to remain in place and have to be stored, 5 years after the end of the business relationship. So if you open an account today and you close it, say in December, at the closure of that account in December, reporting entities are under a duty to keep records for up to 5 years. They have to keep them so that we are able to trace financial steps taken when carrying out financial investigations.
Now, Campbell, as we currently operate in a kind of administrative FIU, for which over time you have been explaining perhaps the 3 core functions in terms of monitoring and analysis, compliance and prevention, and information and cooperation and data exchange. On us as going to be assessed as a country, are the assessors going to look in furtherance the interagency collaboration and cooperation in terms of mitigating the impact of money laundering and financing of terrorism?
Absolutely. That is very key. The issue of how institutions who have the same objective and the same goal work together. That is going to be an aspect of it. They are going to look how we have been able as a country to bring all of these institutions together. The institutions of law enforcement, for example, the police, the Anti-Corruption Commission, supervisory bodies, for example, the Bank of Sierra Leone for the financial sector, the General Legal Counsel for the law profession, the Institute of Chartered Accountants for the accountancy profession. Okay, how we have been able to work together, how financial intelligence is being used by law enforcement to aid them in their investigations, for example. And when they have finished these investigations, how well do prosecutorial authorities like the law officers department carry out prosecutions, criminal prosecutions or civil prosecutions, with respect to what facts they've gathered on investigation. So interagency collaboration is very important and is very key. I'll talk more about that when we come to effectiveness assessment.
Again, you are not a prosecutorial type of FIU that you operate in this country. Most cases when you want to prosecute, you derive your authority through a fiat from the DPP's office. And I'm not sure whether Giaba will like that kind of model for you to actually get yourself involved in, to derive your authority from the DPP's office to actually prosecute. Are they going to look at that particular aspect as a standalone, where perhaps you may have the leverage, the situation where you find people of interest to actually take them to the court all by yourself and having them prosecuted?
Well, you see, the issue of prosecutions, you know, is a dicey one. Dicey in the sense that it is for the law officers department to carry out these prosecutions, and it is for the police.
But there are instances where it will be good for the FIU to champion it from inception to its conclusive phase.
Well, with experience and with what we have been able to see, you know, when we came in, you know, I think your suggestion is a plausible one. But, you know, there has to be administrative arrangements or legal arrangements, you know, perhaps to amend the provisions of the present law to give us those powers access, you know, so that we would be able to take things from the inception. Because at the moment, we do not have investigative powers, nor do we have prosecutorial powers, because, like you said, we are not a prosecutorial type of FIU. But in my experience, what I think we would have to be looking at going forward will be the issue of seeing how we can move from the, you know, the gentleman's type of financial intelligence unit, you know, to the fighting type, so to speak, you know, because the issue of proceeds of criminal activity is endemic in our society. And I, for one, think that government can, there is a revenue trove, in the area of proceeds of criminal activities. If you deprive criminals from the proceeds of their activity, then it will serve as a great deterrent to crime. But the unfortunate aspect of it is that our law enforcement agencies have been depending more on the predicate offenses. You know, the larceny, you know, the robbery with aggravation, the housebreaking and larceny, the fraud. They are forgetting the financial aspect, because every one of these crimes has a financial motive. You don't steal for stealing's sake. You steal because you want the money or you want the property to use. You will go to jail, you know, for some time, but the money will still be there for your keeps or for your family's use. But fancy a situation where you take the criminal, prosecute him, get him time in prison, and you do not only stop there, you take the proceeds of his criminal activity. Tell me whether you think that criminal will have the ethos to go back to his crime or his criminal activity after serving time.
Campbell, what the law says generally on the aspect of aiding and abetting people perceived to be money launderers. I am looking at it from the aspect of beneficial ownership. You may have an organization running for which you could only identify the head of that organization, but when it comes to the shareholders, they are silent. Law is silent about them, and there might be a possible conduit, you know, to actually help aid and abet some of these criminal activities. What the law says generally with respect to those other elements of individuals.
Yes, the issue of beneficial ownership. This is spoken of well in the technical compliance aspect. Now, like I said to you, with the assessment is going to be on the recommendations, the 40 recommendations, and in recommendations 10 and 22 of the FATF recommendations, the FATF standards, they talk about beneficial ownership. Now, part of the technical assessment will be to look that there are measures, our laws have measures to protect the use of corporate bodies by legal persons, the use of beneficial ownership. How is it being reported? If there are beneficial owners in a particular company, we need to see them. We are unclothing the veil now. We are lifting the veil, on owners who prefer not to be known. Now, there have been certain developments in our legislation lately. We now have a beneficial ownership register, which has been developed. We have a corporate governance code now in the country. So part of the technical compliance assessment will be to ensure that nominee shareholders, those who hide at the back, they are not misused. The issue of nominee shareholders, they are not misused for money laundering, they are not misused for terrorism financing. Now our laws are providing for full and frank disclosures, of trustee status to both financial institutions or designated non-financial businesses and professions. So as you see there, assessed countries have to take these measures. They have to take measures so that legal persons are not misused. They have to take measures.
Especially lawyers.
Well, lawyers are just one of them.
Okay.
But you also have trust and company service providers. You have accountants as well.
Okay.
We are not the only bad guys. So you see, we have to look.
So you ensure adequate and timely information provided to the bureau.
So the beneficial owners, on the beneficial owners, yes, you have to provide information. Remember, I told you now the CAC and are working on a beneficial ownership register for our country. That is a very big plus, when it comes into play. That is a very big step in the right direction. So we are becoming, as a country, more transparent in terms of these legal persons, for the simple reason that we don't want them to be used as conduit pipes for money laundering, because of the secrecy of their nature of operations. They are easy to be used. Okay, so you will see a company being floated. You see active partners, but there are nominee shareholders behind whom you will not know, who are doing things behind the scenes, to perpetrate criminal activities. So our laws have to be as transparent so that they are not being misused, for money laundering or terrorism financing activities, and that will form part of the technical compliance assessment.
There has been what I would describe as a complex of conflicting interests, especially when it comes to cross-border declaration of currency. You will have the presence of the NRA authorities, custom officers, and also financial intelligence unit officers. But your presence, to a larger extent, don't seem to be pretty much fundamental. I don't know who takes the statutory role in ensuring that when some of these cases were highlighted, who takes the key role to ensure that the cross-border declaration of currency is to be enhanced? Is it the FIU or the NRA? I recall a situation, the Lungi International Airport, is it in March, where there was a cross-border declaration of currency, and you guys were there, but nothing seemed to be done, as if you were in absolute control. We saw what happened. The bulk of the work, goes to the NRA officers.
That was the subject of a debate this afternoon while I was watching in another station, while the amendments for our act was being tabled by the Deputy Minister of Finance before Parliament. A member of Parliament raised that issue up. But let me come back to what the law says. Now, every man entering or leaving Sierra Leone must, as a matter of law, declare currency where you are traveling out of or you are coming into the country with money which is 10,000 US dollars or its equivalent in leons or other currency. Now, upon the declaration of that amount of money, you will fill out a declaration form. Again, the law provides for relevant officers, and the relevant officers to administer that part of the act is the police or the National Revenue Authority. Specifically, it says a police officer or a customs officer, and customs now means the National Revenue Authority. So they are the relevant officers. They are to look at the facts of your declaration and determine authenticity and determine whether the facts of your declaration leads to a suspicious transaction report. And or when they form that suspicion, the relevant authority, here being the customs officer or the police officer, should report that fact to the financial intelligence units. The way our laws are drafted do not provide for us to be part of the relevant officer. So we are not at the border post. The FIU would be informed, like we were informed in the issue you were talking about. We were informed and we knew about it, and we attended the apprehension, and we lodged the funds were lodged at the Bank of Sierra Leone, and advice was given, that the facts of that matter did not lead to issues of laundering or terrorism financing. Then the money was released. But what the FIU did was to collaborate. The director of the FIU collaborated with the law officers department together with the NRA to get the work of the guy who was caught with the money.
The answer guy.
Right, yes. So the facts of his business, was taken into consideration and investigated. And the volume of money in his hand, was matched against what his stated business was. And then the NRA was requested, to look at issues of tax evasion and whether he has been paying tax. So Anta got the money back, but Anta was being looked upon for issues of tax evasion. So it is not I know when it comes to money, everybody will think about the FIU. Fine, fair enough. But the FIU is a creature of the law. The FIU has to follow the law. Because if the FIU fails to follow the law, it will be charged with overzealousness. Because if you look at the framing of our act, it is a body corporate which can sue and can be sued. So the way our act is drafted does not allow for us to be at the border posts. Maybe that is something which would have to be looked at again. But the standards, I have researched on the standards. That is the standards in many developed countries. It is the police or the customs officers who administer. Remember, we are intelligence. We work not directly, but behind the scenes. So the way the laws are framed does not make for the FIU to be relevant officers. But it provides that where there is a suspicion of money laundering or terrorism financing based on the facts of that declaration, then that fact has to be reported to the FIU for analysis and further action.
Like, what really determines an accomplishment feat of your activities without successful prosecution of criminals?
The number of analysis carried out, the helpfulness with which our analysis and intelligence reports, assist in the investigation and prosecution of criminal activities.
Apologies, during your analysis, does a possibility exist where perhaps the ACC could generate an interest
Absolutely,
individual?
absolutely. The final product which defines our analysis, which is the intelligence report, is disseminated. We disseminate to the particular law enforcement agency concerned. Where we would disseminate to the Anti-Corruption Commission is where the facts of our analysis prove links to corruption activities. Remember, proceeds of crime can be proceeds of corruption as well. Proceeds of crime can be proceeds of larceny, can be proceeds of bank theft, can be proceeds of murder, can be proceeds of child trafficking, can be proceeds of robbery with aggravation. So where our analysis leads to those facts consistent with those sort of crimes, we forward to the Sierra Leone police. So it is for them now to use the facts of what we are telling them by way of an intelligence report for use in investigation and subsequent prosecutions.
There are schools of thoughts which says having an administrative FIU could be the best, rather than the bulk of the job is seen to be done within the FIU itself without segmenting all of those functions. Otherwise, the leadership of that particular institution to a larger extent might be compromised. Does that serve as a better, explanation?
Please come again.
Schools of thought are saying that having an administrative FIU could be the best, where the responsibilities are segmented. You have the law enforcement aspect, where perhaps you analyze your information, your intelligence, then you refer to the police for onward investigation, or it could be the interest of the agency that comes in, right? Where there are cash of money, you will call on the NRA. But in a situation where it's a standalone, you prosecute, you investigate, and you prosecute. The tendency for the head of the FIU might be compromised, and it will, to a larger extent, undermine the fights against financial intelligence. Should it? Does that sound a rather plausible explanation?
I beg to differ.
Why?
The reason being, in every sphere of endeavor where you find yourself, firstly, I would postulate what my late lecturer used to say when we asked him questions at constitutional law class about the separation of the office of the Attorney General and Minister of Justice. He says, no, I don't see any reason why they should be separated. It depends on the integrity of the individual. So I would say to you, having it in one basket, has nothing to do with the integrity of the individual, where you have an individual like the one heading now, who is worth his salt. I mean, we would want to ask, why has that not compromised the robust fight against corruption we are seeing? Investigations have been done in the ACC, prosecutions have been done there by the same ACC, and intelligence-led activities have been done in the ACC. But we have not seen the integrity of the leadership of the ACC compromised. I would rather think that given the circumstances, of our risk assessment, and given the circumstances of financial crime, taking the country as a whole, perhaps it is high time we begin to think about, looking at what sort of FIU would the public want. Perhaps that can be things to look forward to after the evaluation. But let me come back to the issue of the assessment, which is the gravamen of my visit to you tonight.
I know.
I have spoken in extento about technical compliance. Now let's talk a bit more about effectiveness assessment. Yes, effectiveness assessment. So with effectiveness assessment, they are not going to look for the availabilities of the law. They are going to look how well has these laws been enforced. To what extent do you carry out the obligations under the Act? Our legal and institutional framework, is it producing the expected results? Are we having quality investigations as a result of the laws we have in place? Are we having robust investigations and prosecutions? So here, in terms of effectiveness, we are not looking for the availability, or assessors will not look for the availability of the law. They will look at the extent to which the laws, are producing the expected results. So the questions of how well and to what extent are the key questions which will be asked when they are talking about effectiveness assessment.
Fast forward to this effectiveness assessment, what will inform the operational activities of FIU upon completion of the assessment itself? Let's say the country being compliant, largely compliant, or partially compliant, or non-compliant.
Well, before I come to that, let me talk to you about, how it will be done, what they will be looking at. There are 11 immediate outcomes. Now, the first one is risk. We spoke of policy and coordination. Okay. Now they want to know that our country understands money laundering risk. Okay. And our actions are coordinated domestically and internationally. We spoke about interagency cooperation previously. Yeah. So that is one aspect, the first immediate outcome. Then international cooperation. Whether we are able as a country with our partners, our international partners, to gather financial intelligence and evidence which will facilitate action against criminals and their assets. You have supervision. How well are supervisory bodies supervising those under the purview? For example, how well are the banks, the commercial banks, are being supervised by the central bank? Or the lawyers are being supervised for the issues of money laundering, by the General Legal Counsel. Then you have preventive measures. They're not looking only at the enforcement measures, but preventive measures. How well are they being applied? Are these measures commensurate with their risks? Remember, the first issue in outcome 1 is the risk. All countries are supposed to have carried out risk assessments. All reporting entities as well are enjoined to carry out risk assessments for the risk in their industry of business. And when they carry out the risk assessment, they will take measures adequate or implement resources, to combat the risks they have identified, starting from the riskiest to the lowest risk. So that is one thing they would look at as well. Another outcome which we've spoken about, we just spoke about beneficial ownership, how they are prevented from misuse. Then again, you talk about financial intelligence. Are they being used by the law enforcement authorities? Are they being used in their investigations? How well are they being used? What we produce, the products we produce at the financial intelligence unit. Then you have the issue of prosecutions and investigations, which is immediate outcome 7. Okay. Now, immediate outcome 7 is saying that we must carry out as a country criminal investigations on money laundering and prosecutions on money laundering and terrorism financing. So part of the effectiveness assessment will look whether that immediate outcome is being achieved or is being met. Then the immediate outcome 8, which is talking about confiscating the proceeds of criminal activities, whether as a country we are doing that. Now there is conviction-based confiscation, and there is non-conviction-based confiscation. Are we confiscating the assets? Are we allowing the criminals to go away with them? Because the banter is, you deter crime by depriving the criminals of the proceeds of their criminal activities, because that's the reason why they are in criminal activities in the first place. They are not there for fun. They are there for what they can gather from it. Then again, you talk about the issue of terrorism financing investigations and prosecutions. The assessors will be looking how effectively are we doing that as a country. And then you talk about proliferation finance. That is the issue of financing the proliferation of weapons of mass destruction in country. So these are the immediate outcomes which an effectiveness assessment, which is the second ambit of the assessments, the mutual evaluation, would look at. So in totality, one is the technical compliance aspect, and two is the effectiveness assessment. So 1 plus 2 will equal the mutual evaluation assessment.
So
Now we come to how the ratings, okay? Right. You were talking about you know, the low level of effectiveness, high level, substantial level. Now, after the assessors come on the ground, after we have filed the technical compliance questionnaire and the effectiveness questionnaire, which we have sent, they will come on, the assessors from different countries, as you know, appointed by GIABA, will come on the ground. And that is going to take place next month. Now, they will interview reporting entities.
on-site visits.
On-site visits, yes. They will interview supervisory bodies. They will meet with judicial authorities, competent authorities, the police force, other law enforcement agencies. And after that, they will come to their conclusion based on what we have answered in the questionnaires they have sent to us and based on what they have found out on their on-site visits.
If there are huge discrepancies.
If there are huge discrepancies, then we will have a low level of effectiveness. That means that the 11 immediate outcomes are achieved, they are not achieved, and if they are, even if they are achieved, it is to a negligible extent. Therefore, they will recommend for fundamental improvements to be made to our system. And then the next year will be moderate level of effectiveness.
But in all of this does not precipitate international isolation at all.
Well, the isolation part will come in where the assessors would have recommended certain priority actions to be taken post-evaluation, and yet the countries do not take them. I think that is where the isolation will come in.
Do you talk to those other reporting entities to tell them that how much are they aware that the assessors will come in and this is what is expected of them to be doing for the rest of the period they are in here?
Well, some of the reporting, most of the entities have been with us, because when we were completing the technical assessment questionnaire and the effectiveness assessment questionnaire, we did not sit alone as an FIU in a little room with coffee and do it. We collaborated with many of our partners, okay? The reporting entities, supervisory bodies. We had a very large, the law officers department, the judicial authorities. We had a large conglomerate of persons from different institutions, reporting entities, you know, law enforcement, you know, people who have even assessed other countries, who are Sierra Leoneans. They were all with us, you know, and we completed these questionnaires together. And they are still with us while we are reviewing, because we are just about completing the review of the draft comments. Okay? So we sat down as a country and completed these questionnaires. And we have held certain public relations activities to let the wider public, not only the reporting entities or the supervisory, the wider public, to let them know that this is what is happening, and it will not be an assessment for the FIU. It will be a country assessment. Okay, so everybody is in the loop, and I think everybody is on board. But we don't only want to limit ourselves. We want to let the wider country understand what is going on, because a good rating in this assessment will increase confidence, you know, international confidence in Sierra Leone. Investors wanting to come to Sierra Leone would look for actions, you know, that has been taken, you know, to improve our money laundering
picture of
regime.
progress made.
Absolutely, absolutely. A picture of progress, a picture of rebranding the country's image, you know, bringing us back from the brink in terms of financial malfeasance and stuffs like that.
Um, Franklin Campbell, we don't seem to be having much time left again in the studio. I recall a situation where the Financial Intelligence Units under the current leadership of Mr. Mohammed Kone have held several engagements with especially people they consider to be landed individual lawyers, casinos, operators, the extractive sector. I was wondering as to why do we need to tell especially lawyers dealing with their clients without them knowing what constitutes a risk of money laundering activities? Why do I need to have a bulk of them to tell them that A could be dangerous, B could be a little bit risky, and C could be overall effectively bad? Why do I need to tell them? Highly landed individuals.
Well, you see, this is why I recall an old professor who said to me, as a lawyer, you have to try and know many things. Because it is the only profession where you will be a lawyer and a medical doctor will be there sitting in a gathering and the lawyer is there and somebody breaks down ill, and instead of asking the medical practitioner about what to do, which is his area, they will ask the lawyer. So, coming back, these I'm sure you're talking about the preventive workshops, which we held with support from EU and SAMWA,
yes,
Giaba. Yes. Now it is good to let them know. I have to be very honest with you. Not all lawyers or accountants or casino people know about laundering. They will know that there is an issue called money laundering, but they will not know that it involves proceeds of criminal activities. They would be wondering whether the money is being washed, as in the literal sense. So I think it is good for lawyers to know, especially the preventive aspects. They have to know that they have to do certain things, because this is a new phenomena which is coming into our practice. For example, the guidelines and directives we are developing now is requiring lawyers to carry out due diligence, to carry out know your customer, to keep records for a period of years. These are all new things which has to be rolled out to them. The risk of terrorism financing. People have to know what it constitutes. What is it all about? Who is a terrorist? What is financing of terrorism? What is proceeds of criminal activities? These are preventive measures. The Act does not provide only for enforcement. Enforcement is key, yes. But preventive measures, let me go back to the immediate outcomes. Okay? The preventive measures are very key as well. They're very key. You see, it's immediate outcome 4. Financial institutions and designated non-financial businesses and professions adequately should apply preventive measures commensurate with their risks, and they have to report suspicious transaction reports. So we have to train them how to do it. If they do not know the rudiments of the preventive measures as stated in the Act, it would be very difficult for them to, take measures to report certain threshold reports they have to report to the Financial Intelligence Unit. So it's all part of the learning process. Okay? I know legal people are deemed to know everything, but this is an aspect which is relatively new to our legal jurisprudence. So we have to teach people. We have to spend time, not only to run after people, but to sit people down in a room and talk, just like we are doing now.
So conclusively, what will be your final remark to especially reporting entities that they must brace up themselves, other financial institutions, that we are in for a mutual evaluation and they should be confronted with specific questions and they should know how to respond and what to say, and at which time they should say these, that at the end of the day we'll have a favorable score sheets.
Well, what I will say to them is, we are not going to tell you, we are not going to put words into your mouth, but we would say participate in the process by firstly making yourself available. We know you are busy people, but please make yourselves available. Provide records of what you have been doing when required to do so. Provide statistics of suspicious transactions, for example, you have reported. Provide us with information on the effectiveness of the use of our intelligence we provide. Everybody must play their own part. Provide us, for example, NRA with declaration forms for analysis. Join us together, because this is not a financial intelligence unit business alone. It is a countrywide business. And if we are to succeed, we have to march together, side by side. Thank you very much.
Thank you so much, Lawyer Franklin Campbell, Head of Operations Financial Intelligence Unit. We're looking forward to having you in subsequent edition, perhaps before even the commencement of the on-site visit of the assessors into the country.
Thank you.
And viewers, this is how I bring down the curtain into this edition of the program Familiarize with the Law, with my guest being the Head of Operations Financial Intelligence Unit, Lawyer Franklin Campbell. Till then, my name is Abdul Rahman Kamara. Have a wonderful